Great. Well, hello, everybody. It's great to be back in sunny Dundee. And I had a fantastic time last week in Lagos and Accra. And I really enjoyed meeting many of you face to face. And I'm delighted that you're back here online to join this session. And for those of you who are watching the recording, welcome too. I know many of you find the recordings really useful. As always, if you have any questions, just post those in the Q&A. And reach out to us if you're watching the recording. If you have any questions, email them in or use the WhatsApp group and we'll respond. So today we're sort of moving on with our great session led by Kelsey and the team, and we're doing oral skills and presentations. So any housekeeping, Libby, before we go on to Kelsey?
I think you've mentioned everything, Professor Peter. Just a quick reminder about the Q&A. If you do feel comfortable and want to ask your question verbally, then raise a hand and I can unmute you. And also just a quick reminder to all those schools that haven't yet been in touch with workshop times. I'm looking to schedule these this week, starting next week and the week after. So please get those times, as many available times as you have, so that we can try and find a suitable time for everybody. But I think without further ado, I'm going to hand over to Kelsey and Ria. I think you'll be starting us off today.
Yeah, so I'm just going to kind of introduce the slides. Let me get them up. So as Peter said, this week's is on oral argument and presentation skills. This is super important in a moot because a moot is an oral argument. So this is all kind of the judge is going to care about is your legal research can be great, but if you're not able to kind of confidently and clearly give your submission and your argument to the judge, then you're not going to score very highly. So this presentation is super important, but also important is that you do get involved in the workshops we're going to do. That's really your opportunity to be able to talk to us and actively kind of deliver some information so we can tell you if you're on the right track. But yeah, I think Ananya is going to start us off with the presentation.
Hi guys, so these are just the learning aims for today's lecture. So at the end of today's lecture, you'll be able to present yourself confidently and clearly, understand how to introduce authorities in your submission. You'll also be able to reply to judicial intervention. We spoke a little bit about this last week as well. You'll also be able to identify points for rebuttal, and we'll give you some tips on how to use your time effectively. So just a quick recap of what mooting is. So mooting is a competitive mock court appeal case. Now the teams present submissions for each party and they seek to persuade the judge that their interpretation of the law is correct. Each moot has two teams competing against each other, and the winner is decided both on advocacy skills and legal knowledge. During your arguments, you'll be asked questions by the judges or the judge, and that's judicial intervention. So yeah, we had a few people asking us how the moot is going to be marked. So the way this moot and most other moots you might do in the future, they're generally marked based on a couple of different factors that the judge considers. So if you look at it, you'll see there's some of them that are highlighted in blue. Those are the ones we're going to cover today. So today we're going to do oral presentation, relevance of authorities, speaking skills and use of etiquette, response to questions, effectiveness of rebuttals, and use of time. So, right, presentation. So during your submission, remember, nerves are normal. It just comes down to what you do with them, really. I personally believe that a little bit of nerves, being a bit nervous, really does help. You know, you have that little bit of adrenaline, but just be a bit careful. You know, just be a bit careful that the nerves don't translate into you talking really fast. That just comes down to practice. Stand in front of a mirror and just you know, read your submission out loud over and over again. Pace yourself, time yourself, and yeah. I'd also say during your submission, keep an eye on the judge. They'll be taking notes, and you know, if you see them struggling a little bit to keep up with what you're doing, that's just a sign for you to slow down. And yeah, you know, you could also, like, for example, you've just directed the judge to a quote in your judgment pack, and you see that they're struggling a little bit to find the page. you know, that's your sign to maybe just wait a couple of seconds, ask them if they have sight, and then if they do, then you can continue with your submission. Another good thing is think about how you want to use your voice. Now, there are three really important bits. There's tone, emphasis, and resonance. So with tone, really, you want to vary your tone, right? Depending on what you're talking about, are you making an important argument? Are you maybe saying a quote? Are you concluding, like, is it a sub-conclusion? So depending on that, your tone and pitch will vary, and keeping them like varied is good because it keeps the judge and the audience tuned in, interested, and engaged in what you're saying. And that's important because really you have 7 minutes for your submission, and that's quite a long time for a judge to sit down and really understand exactly what you're saying. So if you can really help them out with tone, emphasis on really important arguments, and just resonance, you'll see that when it comes to mooting, you can moot in almost any kind of room. It could be like a little room, small room that like fits 4 people, or it could be a huge moot court that's like really echoey, really big, and you really need to project your voice without coming off like you're yelling. So it's really just down to practice. Stand in front of a mirror, maybe, you know, practice in front of a friend, and yeah, you'll get the hang of it. One more point, when you just need to remember that your submission is like a story. You're kind of like, you know, guiding the judge through it. So be really clear when you're introducing like a new point. If you're rebutting, if you're concluding, it really just helps the judge understand where you are in your argument, and like in the off chance that they've kind of lost you somewhere, they know where to pick up from and what's going on. In terms of body language, I'd say eye contact is key with the judge. It just shows the judge that you're actively listening to them. It also really helps because if you're already making eye contact with them, so if, you know, they ask a question, there's judicial intervention, you're kind of already ready and you're paying attention. It doesn't catch you off guard. We had to do a few moots online, like during the pandemic and stuff like that. And I will tell you that trying to keep eye contact with the judge online, staring into the tiny little camera, is it's a bit hard, but definitely not something you can't do. I'll also say fidgeting excessively can distract the judge from the argument you're making. So 7 minutes, try and stay calm, try and keep everything under control, and you should be good. Oh, and the last bit, when it comes to mooting, seating is really like the arrangement is very specific. You'll have appellants on one side, respondents on one side, you'll have the judge and the clerk on the other side. So, you know, as counsel, you shouldn't be straying around the room, you shouldn't be walking around, you'll be seated, and then when it's your turn for the submission, you stand up or you go to the podium, you know, do your submission, and then you come back, sit down, and then wait for everyone else to finish.
Thanks. And Anya, I'm wondering if I can, a great question in from Nomi. What should we do if we don't know or are not sure about the answer of a question that the judge asks us? Great question.
That's a really good question. I'd say take a minute to think about what just like understand what the judge has asked you. And if you don't understand the question, even after taking a little bit, it doesn't hurt to ask the judge to maybe rephrase the question and just take a little bit more time to kind of, you know, figure out. It just comes down to how well do you know your arguments in and out. And you should be okay then, really, with whatever's thrown at you.
If I could just jump in there, I've got a question as well, but just to add in a comment. Those people at the schools that I visited last week will know that we touched on this very issue, and I gave some techniques that Rory, one of our trainers from last year, exhibited very well in one of the mooting videos. There is the sipping water technique, because you're not really desperately thirsty, but you're trying to get the little gray cells to kick into action and think of the answer. And Anya, you correctly mentioned the repeating the question. Basically, again, that could help improve your understanding of the issue, but equally could gain you some time. But the other element to think about really importantly is that a mooting team can have up to 4 members. So you could have Kelsey, junior counsel, Ria, senior counsel, and then the two legal assistants, Ananya and Libby. And Ananya and Libby are not just there to make up a big team, but they are there to help their counsel. So as soon as a question is asked, Ananya and Libby should be scribbling down the answer just in case Kelsey is lost for words or her mind goes blank, so they can pass the answer to her and then she can read it out. And so it's really, really important to develop lots and lots of trust between the legal assistants, members 3 and 4 of the team, and the two mooters. That's so important. And they can also help with developing submission arguments for rebuttal. So we talked about that in quite some detail last week in the schools in Lagos and in Accra. So that was an extra point. The point I was going to make, a great point about making eye contact, Ananya, and as you say, it is super hard to do that online. But if I look at my big screen, which I prefer to look at, I'm obviously not looking at you. So the top tip for making eye contact when you're online is unfortunately just to stare into that little camera on your laptop. And that way my eyes are focusing right on you, the audience, even though it might be more obvious for me to be looking at one of my big screens. So that's just the practice you have to do. Look straight into the eye, straight into the camera, and that's the best way to convey eye contact when you're delivering a presentation online. And that's whether you go on to become a lawyer or not. Life in the future, whatever job that you take, is ultimately going to involve some form of hybrid engagement. And it's really, really important that all of us become effective at persuading people, at engaging with people in the online format. So yeah, that's my top tip. Look into that little camera at the top of your laptop screen. So that's it for me. Back over to you, Ananya.
So when you're addressing the judge, you should refer to them as my lord or my lady, or your lordship or your ladyship. And those depend on the circumstances that you're mooting in. So if you're wanting to direct the judge to a page of your judgment pack, you would say your ladyship or your lordship. So it'd be if I could direct your lordship or your ladyship to page 6 of the digital bundle. For your ladyship or your lordship is generally, if you're going to say the word you would say your lordship or your ladyship. And then if you say my lord or my lady, it's more to emphasize a point, like if you were going to say their name. So you'd say, my lord, the submission of the appearance relates to this, and it's usually at the start. And you should definitely make sure to refer to the judge correctly. If you're not sure, maybe at the start, how they want to be referred to, you can always ask them just to make sure that's correct in your submission.
And Kelsey, if I can jump in, what's the top mistake that so many people make?
Saying, well, yeah, they say your lord.
Your lord or my lordship or my ladyship. And even worse than that, the top mistake that sort of
Your Honor.
No, not even your Honor, but the even more fundamental. What did you encounter last year, Kelsey?
Sometimes, yeah, people misgender, so they'll call me your lordship or my lord, and I'd like to be referred to as my lady or your ladyship. So that's the thing. If you're not sure, then just ask and we'll tell you, and it saves you making a fool of yourself. If you're going to write a speech as well, I would say here is that I would never write my lord or your lordship into your speech. You can put my L and your L-ship, like just the letter L. And then it just lets you know that you're either going to say lord or lady or lordship or ladyship.
Other thing that I raise with some of the schools when it comes to beginning your submission, and this is something I learned at the end of my first 6 pupillage, just before I got on my feet in my second 6 pupillage, is when you stand up in court the first time, do not say good morning, my lord, or good morning, my lady. That is, yeah, my pupil mistress, that's the name given to your to the senior barrister who looks after the pupil master or pupil mistress. I have 3 pupil mistresses. She had been marked by an experience during her pupillage when she jumped up super keen and said to the judge, circuit judge in England, good morning. And promptly, circuit judge responded to her, Miss Heppenstall, it has not been a good morning today. So you may have a grumpy judge who does not like good morning or good day. So just begin, my lord, and then make your introduction, or my lady. Ria, sorry, back to you.
No worries.
I'm
If
on a
you are
roll
wanting
today.
like an
enjoyed being
alternative,
at schools last week.
if you are wanting an alternative to good morning or good afternoon, you could always go with if it pleases the court. That's always quite a good one that you could put in there instead. So when it comes to introducing yourself, it will be the senior appellant that introduces the court, and you should offer the judge the facts of the case just in case they aren't aware of them. But if you are giving them, I wouldn't maybe be too elaborate about the facts of the case, and just try when you're looking at it to pick out the key points and just go through those for your judge. You should introduce yourself, and then if you're the senior, you should also introduce your junior. So you'd want to give your title and your full name, not just your first name. So instead of saying, my lord, my name is Ria Mehta, it would be, my lord, my name is Miss Ria Mehta, or Mr., depending on who you are and also who your junior is. You should also reference a judge to your skeleton argument and briefly explain, depending on the side you are, your grounds of appeal or response, and then submit those grounds. And this is to kind of give the judge a roadmap of your argument so they can be led through your argument in quite a simple way, and they're aware of the structure and the main points that you'll be making. So when it comes to introducing cases, you'd introduce the case by its citation. So for Donoghue and Stevenson, it would be, instead of said Donoghue versus Stevenson or Donoghue v. Stevenson, it would be Donoghue and Stevenson, and then I've just got the citation there written, worded, so that we'd be able to say it as you'd say it in your speech. So it'd be heard in 1932, and then you'd say what court it's in, so in the House of Lords. And then after the report, it usually has a couple of initials, and that'd be where it's reported in. So it's AC for this one. So it'd be reported in the appeal cases, then it has a little number on the end. So beginning on page 562. So then you direct them to that case in your bundle or your judgment pack, and the judge would usually nod or indicate they found the page. Maybe they'll smile at you. And if they haven't done that, you can usually maybe wait a couple of seconds and then ask, does your lordship or your ladyship have sight? But I wouldn't straight away go for that. I'd maybe wait till they give you some sort of suggestion that they can't find it. So as I previously said, definitely offer the facts of the case to the judge. And if they ask you if they're relevant, try and have that answer maybe ready, because then if you say they're not relevant and they still want them, then it just creates a little bit of an awkward situation. They might ask to hear them briefly rather than a long explanation of them, or they just might not want them at all because they already know the case. You can then direct the judge to the page of the bundle that you will quote, and you should provide the judge from the judgment and read the judge the section as well.
Perfect. So now I will be speaking about concluding your submission. So when you are concluding your submission, essentially what you would be wanting to do is to summarize to the judge everything that you've mentioned in your submission. So your arguments, just to remind them again what you are arguing for and the facts that you've mentioned. So if you are the junior counsel, you will be concluding for your side and not just for yourself. So basically, if you are the second person to speak on your team, you would have to also conclude and remind the judge of what your partner has mentioned at the beginning, just to conclude for your team. So make sure that your conclusion is strong and that it, in a sense, illustrates all of the arguments that you've mentioned throughout the moot. And at the very end of your submission, do not just sit down. So once you've mentioned kind of your final argument in the skeleton, make sure that you thank the judge or you ask the judge if they have any further questions. So for example, as you can see, you could quickly just mentioned or say, if the court has no further questions, I will conclude my submission. And after saying that, you can proceed to conclude and just summarize all of the arguments. So time is extremely important, and I think we've mentioned it a few times in our lectures, but the time limit for each mooter is 7 minutes. So there will be a clerk present alongside the judge. So what they will be doing there is essentially just doing all the timekeeping. So the clerk will inform you when you are presenting the different times that you have left. So as you can see, Libby just showed 2 minutes and a minute. There we are. So essentially, as you can see, if they flag the 2 minutes paper, you have 2 minutes left. Accordingly, for 1 minute, you have a minute left. So usually if you see the 1 minute paper being flagged, I would suggest quickly beginning your conclusion to kind of summarizing what you have left in your argument. And of course, when you see the paper time, when it's been flagged, essentially it means that you've finished your 7 minutes. So if that ever happens to you, you should essentially just finish your submission, just thank the judge, and maybe just spend another 10-20 seconds kind of concluding. Sometimes you might be in the middle of your final argument and you see the word time. It really depends on the judge. Sometimes the judge will be kind enough to kind of let you, the judge won't be very nice for this competition, I'm assuming. So basically, just finish what you're saying when you see the word time being flagged. So when you're practicing, it's so important to kind of record yourself, get a clock out and kind of time your speech. Of course, try to be accurate in the sense where try to really practice the speed as if you were presenting it on the real day. So don't speak too fast, don't speak too slow, because you wouldn't want to speak too slowly and risk not bringing out all of your great arguments during your submissions.
If I could just jump in. Yeah, great points, Hannah. It is the only exception to the 7 minutes would be if I have not asked you a question during the 7 minutes and I ask you a question just at the end. Just because time goes up, that is not a pass. It doesn't mean you can avoid answering the question. If I ask a question at 7 minutes, you still must answer it. But normally we try and ask the question during the middle. So as I said to all the schools I saw last week, it's really important that you judge how much you're going to say and anticipate that you will be asked the question and how much time you'll have to devote to answering that question. So that is difficult. So one of the tips that I suggested, and Kelsey, look forward to your comments on this, where you've got points written on all the different areas you wish to cover, I would almost suggest a highlighting scheme where you highlight certain bits of each submission in green, that they are the most important elements, and then you can highlight others in yellow. They are additional things you can say if you've got time. So I know in the past, sometimes people have adopted a safety first approach to make sure that they get through all the material they've written down. But if those people are asked a pretty simple question, we've had situations where people have finished their submission after 3.5 minutes or after 4 minutes, and that is not a good thing. It becomes a very light submission. And people have done that with a good intention. They think, want to make sure all my points are made across. I'm going to be asked a question. Judge Peter might ask me lots and lots of things, therefore I've got to keep 2-3 minutes for that. But then they run out of things to say, and that just doesn't look good. At the same time, on the other hand, if you've got lots written down and you try and get through all of it, if I ask you a complicated question and you've lots to say in answering that, you may not make it to your last submission, and therefore you will lose points if you've not covered that. So you've got to be super flexible. I remember, as Ananya said at the beginning, when you start the case, you offer to introduce the facts of the problem, or you offer to introduce the facts of the problem, the cases that you're relying upon. The judge may say, yes, please give me a synopsis, or she or he may simply go, I'm obliged, I've already considered the facts of the problem, or I'm aware of the facts of that case, please take me to your first submission, or please take me to the legal point on which you wish to rely. So if you don't have much to say on the legal submission, again, you could finish very, very quickly. So you must always be flexible. Kelsey, about the highlighting point, is that something you've used or tried?
The way I do it is I always put, I kind of do a bit of highlighting. So I usually put things in red near the end of my submission that I can leave out if it looks like I'm gonna go over time, and so it's really like I always feel like the first kind of the first 3.5 minutes of your submission are kind of you testing out what pace is happening. And if you realize that you're going way too slowly, or the judge has asked you some questions, then that's when the end of the submission can easily be shortened. There's a couple tips we've got up here, but I'll just mention a couple that aren't up here. Oh, lights went off. You could always shorten your conclusion. It doesn't need to be exhaustive. So if you've got that 1 minute or you've got time, just make your conclusion as simple as possible, one sentence. What's another thing you could do?
Yeah, I definitely would have said conclusion, just have a short one and a long one, like a long one that you can say if you have time, short one if you don't. And maybe if you've got analysis of a quote, you can have something that's quite extensive or bring in another legal principle. But if you've not got time, maybe it's just, here is where the quote is relevant, rather than.
But the best way to avoid kind of that time issue is just timing yourself beforehand and going at the right pace, like Hannah said, because then you can write down in your speech, I'm supposed to be here at 1 minute, I'm supposed to be here at 2 minutes, and you kind of know whether or not you're on track. But I'll let Hannah talk about the rest of the things.
I'd maybe say also don't pick quotes that are very, very long. Maybe just go with slightly shorter quotes rather than quotes that are about 4 to 5 lines long. Maybe you can just say in the interest of time, like I will paraphrase or something.
Perfect. I feel like everyone really covered the points, but just to kind of summarize what's been mentioned. So like Peter said, it will be included in the time judicial intervention. So, just make sure that you leave, I would say 7 minutes. I would try to maximum would be 5 minutes if I'm practicing. So just make sure that the speech is not longer than 5 minutes. And of course, when you're practicing, try to speak as though you would on the day. Don't speak extra quickly. Just so that you think you have more time. And of course, as mentioned, don't be too elaborate when you're trying to explain the facts of the case. I think Ria mentioned this in her part. And of course, try to include relevant authorities because time is extremely important. And at the end, you can see, do not assume the judge will let you go over the time limit. So as soon as you see 1 minute, you should really get going on your conclusion. And when it's time, thank you so much, that kind of thing. But yes.
But yeah, just to elaborate on kind of the relevant authorities point before I move on to the next slide, we did have some people who tried to mention almost every case that we've given them. We've given you, I think, 8 or 10 cases, I can't remember, and they're to be used by both sides and by kind of either the junior or the senior. So realistically, you shouldn't be saying more than 3 authorities or 3 quotes. You will not have the time for that. So it's all about kind of using less authorities, but being able to develop them and apply them in like the strongest way you can. So don't just think that, I'll include all the authorities they've given us, because that's not going to get you any more points, and it'll make your life so much harder in the moot. So I think my slides are on judicial intervention. So when the judge asks you a question, it's really important to remain calm and think about your answer. Do not worry if you have to take a 10-15 second kind of just thinking about the question. You don't need to talk immediately, because sometimes you'll say the first thing that comes out your mouth and that might be the wrong answer. So it's better to just take a second, think about what the judge has said. The judge understands that like what he may have asked might have thrown you from your speech. So they're not going to remember if you took that kind of small pause. So really do not stress about it. The judge wants you to get to the right answer, and he may also ask kind of follow-up questions. So again, the judge is not trying to catch you out or argue with you. They just want to see how well you can kind of go off your argument and whether you know what the legal principles are that you're talking about, and whether you actually know your argument and can back it up. So always keep your pace slow and make sure your etiquette remains formal. So in terms of that, we mean make sure that you say things like, it is submitted. You don't say, I think, or I believe. Make sure you still say to the judge, your lordship, your ladyship. Make sure that you don't say or or
don't be frustrated.
It's
just like you do know they're going to ask you a question. It might come at the worst time in your speech for it, but just remember to be respectful.
If you really don't know the answer, you can sometimes say, you can ask the judge if you can consult with your partner, and you can just say, my lady, please may, or you can ask them also to rephrase the question. So you would say, excuse me, my lord, I wish to consult with my learned junior on this point. I would maybe change that and say that more as like, if it pleases your lordship, could I take a second to consult with my learned junior or senior? Because I wouldn't just tell them, like they kind of have to give you permission to do that. Not all judges are going to allow it. And if it's a really simple question, like, is this case binding? That's not going to fly. So the easiest questions are to prepare for are kind of the most obvious ones. We're going to ask you if a question's binding. We're going to ask you kind of obvious like holes within your argument. So if you can already look at your speech and identify what's the weakest argument I've got and write a paragraph about how to respond if a question you get asked comes up, then, you know, I mean, you don't need to do all that thinking on your feet, and you can just focus on remaining professional and making sure the judge understands your answer.
I can just say a little bit word about remaining professional. I had a great training session in one of the schools last week, and we talked about judicial intervention. And obviously, we hadn't considered any cases. It was just doing this sort of off the top of our heads. But I asked the question about a case that one of the students had considered last year, and the reaction was very, very good. And I'd like to share it. It was the student, the mooter, was taken aback and went, when I asked the question, that is not what you're supposed to do. Even as a barrister, even as a King's Counsel, you will be asked questions by a judge that you may not immediately know the answer to. It is so important that you always maintain your discipline, that you remain calm. You do not give the judge, the court, your instructing solicitor, your lay client, the impression that you're absolutely panicking inside, like, oh my goodness. So you don't sort of open your mouth, you don't look like the sort of startled rabbit in the headlights. You most definitely do not do this. You can ask the judge to rephrase the question. My lord, that is the most interesting question. You're thinking, and you try and say something, but do not gamble. So my lord, Miss Mehta, is the judgment on which you rely, is that binding on the court today? And Miss Mehta goes, 50-50, do I say yes or no? If it's the wrong answer.
Yeah.
And again, if you're asked, as most of you will be, if the judgments on which you're relying are binding, you must be able to state why they are binding. And the best answer to that question, so Miss Mehta, is the decision of Donahue and Stevenson on which you rely, is that binding on the court today? And Miss Mehta, if she's giving a basic answer, will say what?
Yes.
If she is giving the A-star answer, she will say,
my lord, this is binding on the court today because it is in the UK Supreme Court, and that is the highest court in the UK, therefore it would be binding.
Absolutely, and we are in the Court of Appeal, House of Lords, but we're in the Court of Appeal. Yep, that's it, that's the top answer. You say I ask questions all the time.
I think one of the things I was going to say is that actually these questions, the ones about, you know, if a case is binding, these are the ones that you can really prepare for beforehand. So you should have a stock answer to these kind of questions already prepared.
Yeah, and there's no kind of, if you do get asked a question that you don't know, ask them to rephrase it, or just take a second and say, that's a very interesting question you raised. If you even think that the question they've asked has, like, you think they're wrong, basically. Sometimes it happens. Sometimes a judge asks a question and you can tell that the judge is confused, because I've been a judge and I get confused very easily. You can remind them or try and tell them politely that maybe they are wrong. So you could say, if they say something, you say, my lord, it's respectfully submitted that while the point you raise is a considerable one, in this instance, it does not apply, or it's not at, what's the word, dispute today, or something like that.
I'm a little unsure if it's this way in this specific competition, but when I moot, sometimes a judge will ask me a question that's more relevant to my senior than to my argument. And so instead, I would say, my lord, I respectfully submit that this point of law would be expanded upon by my senior, or if it would look even better if you'd be able to know your senior's argument and give a little bit of an insight to it as well.
And some, no, go ahead, Peter.
Yeah, just on that point, I'm glad you said that, Rhea. So last year, we had a Q&A session with a series of LLB alumni, and our most eminent LLB alumnus, his name is Tim Ike. He's a King's Counsel, and he is the UK judge at the European Court of Human Rights in Strasbourg. That's one of the most important judicial positions an English-trained lawyer can occupy. So Tim, in his Q&A for the students, talked a bit about sort of mooting, and he's coming back to give us a lecture in February. And one of the tips that he made was that he recalled one time when he was appearing in the Supreme Court, and he had a high-level public law human rights practice at one of the top chambers in London, and appeared many, many times in the Supreme Court. And one thing he reported back to us was, he remembers his opponent, another QC then, stating to one of the Supreme Court justices when he was asked a question that, "Oh, my lord, I shall come to that later in my submission." And that landed extremely badly. It is almost suggesting, well, it's not almost, it is suggesting that the QC knows better than the Justice of the Supreme Court. And it's sort of like, listen, chum, I'll address that point when I come to it. You're not going to interrupt my logical flow. That is not a good idea. So Tim reported to us that he was absolutely shocked that the King's Counsel now actually said that in the Supreme Court of all courts. So it is difficult if the judge asks you a question that you're not immediately about to explain. If it comes late in your submission, it means you're going to have to adapt what you say. But the judge is in charge. It is his court, it is her court. They will determine the order in which things are addressed. You must be prepared to adapt to that. And as Rhea says, if it's your senior counsel who's going to address the point, it's easier then to sort of say, my lord, I respectfully submit that very, very valid point shall be addressed by my leader, by the senior counsel. Or if, as Rhea said, if you can mention some of the points, not saying too much because you don't want to steal all of your senior counsel thunder, because she or he might have not much to say after that, and he or she should not be repeating exactly the same thing again. If you can say a little bit, that would be better still. So all about flexibility. It's all about showing your respect to the court, and even if you think, why did he ask that question? The point is, he asked that question. He's the judge, she's the judge. We must answer it to the best of our ability.
Okay, I think we're done. Clearly the slides are like missing some key points about judicial intervention, so I might update them before we send them off, or just make sure everyone watches the recording, because these are really good things that we're all adding. So the next thing is rebuttal. And so we've kind of touched on briefly what rebuttal is. It's where you have in your speech written in that you are commenting or criticizing the weaknesses of the other side's argument as they gave it within the moot. So we do expect that mooters are able to not only just say, these are the advancing arguments for my for the appeal that should be allowed for my side of the argument, but you're also saying, this is why these authorities or this argument that the repeal should be denied should not be listened to by the judge. So you should cover some rebuttal in your submission. It doesn't need to be exhaustive. You just need to put in a couple sentences that say something like, my learned friends across the bar have argued that this applies, and in response to this, it is submitted that it doesn't apply, basically. Something like that. You'll already be preparing both sides, so we do expect you to know the strengths and weaknesses of the other argument and be able to incorporate that into which one you're doing. So this could be easy. You could say that a case that the other side is using is not binding, or there's a better authority to use, or that their argument didn't consider one very certain or specific point of law, and that you can just highlight to the judge. And it shows the judge that you're listening to what the other side is saying as they're giving the submission. So you can write down points points that, so here's the thing is that like in your moot, it's not just about your 7 minutes. It's also about the other side's 7 minutes and 14 minutes, and making sure that you're paying attention to what they're saying. You're picking up the questions that the judge is asking them. Because if the appellants have given their speech and the judge said, but why are you using this case? It's not binding. The facts aren't relevant. It's a very old case. Then when you give your speech, what you want to do is show that you've listened to what the judge said. And you can just add in a sentence that says, as your lordship has rightfully pointed out, this case isn't binding and we shouldn't listen to it for this reason. So the judge will just give you extra rebuttal points for that. And it's not that difficult. You already had that in your submission. You're just adding a sentence that says, as the judge has just kind of pointed out there. Yes. And if you don't include any rebuttal, it might be that the judge is going to ask you to respond to the other side's argument. And this isn't as good because they get to pick the topic that they want to ask the question about, basically, and it's harder for you to prepare. So if you're not already making those connections between the argument, the judge is going to kind of force you to do it almost. And again, it doesn't need to be exhaustive. You're going to be prepared both sides. Essentially, a moot problem is two sides of the same coin, and very much that you'll be able to have arguments for both, and they'll kind of tie into one another. And sometimes rules can be interpreted very flexibly and subjectively, and you can kind of choose which facts you discuss for either side.
I've got a couple of really quick points about rebuttal.
Yeah.
One thing that I always do with my partner that judges always look quite well on is that if you have a point for rebuttal that might not apply to your argument and it's for your senior, if you write it down and just pass them that, it can show the judge that look, your arguments are cohesive, they fit in together, and this is us proving that we can put it in together and we're a team rather than just two people who've researched and are presenting independently. And also, like with everything else, rebuttal has to be done respectfully. It can't be, you are wrong, here is why you are wrong. It's more so it's more so always my learned friends or my learned colleagues and something like that.
Yep.
Just one little point on respect. You show your respect by answering the question the judge asks. You show your respect by using appropriate language. You show respect by not chewing gum during your submission. We did have one student last year who chewed gum all the time that the student was speaking to me. That is not acceptable. That student got 0. So very important to be respectful. Shouldn't have to say it, but it happened last year. Do not chew gum and make your submissions.
Okay, so the last thing is just terminology. But just before we get into it, I think what we've kind of pointed out in today's lecture is very much that there's some elements of oral presentation that you can prepare for in terms of timing your speech, making sure that you kind of speak clearly and slowly, making sure that your argument is cohesive in terms of, okay, I'm going to introduce this at the beginning. So the judge has a roadmap of what I'm going to say. These are the order that I'm going to speak in. I'm going to rely on these authorities and make sure that it flows nicely. Don't jump between points and kind of develop those points. So that's all about stuff that you can prepare for in terms of oral presentation. But there are going to be questions that come up on the day that you maybe don't know the answer to. The judge might ask you several questions, which means your timekeeping is behind and you are kind of rushing to finish your speech and you need to change it. The respondents might bring up a point that you didn't consider and you have to quickly add that in to your speech and kind of respond to it on the day. So I think half of a moot is being able to be flexible on the day and be able to alter your speech and what you're saying and what knowledge you have. And really the best way to do that is to just know what your argument is inside and out. I know it kind of sounds like a lot, but at the end of the day, you're the one that chooses what you're going to argue. So it's not a big ask for you to just make sure that you've thought about all the information and all the weaknesses and strengths of that argument. Yeah, I think that's all I would say.
I definitely think flexibility is quite important. Kelsey judged me for a moot once and moved me from my first case to the middle of the argument in my third one, just to see how I would cope with it. And it's just quite important that you can work all of it, even if maybe you carve up your argument into chunks and then it's those cases that you move about rather than just sentences that you move about.
Another point on flexibility and kind of adaptability is that we are doing this online, and that there might be technological issues in terms of maybe your microphone's not working, maybe we can't see you, maybe you have to go to a different room. We're very patient in terms of we'll kind of wait here, so don't stress about that basically. But if you could maybe have a test run beforehand just to make sure that all the technology works and you have your setup, that'll make everything more seamless for us and less stressful for you as well. So, okay, I think we've gone through most of these terminologies before. So I don't know if there's any that we have to cover again, but they're there in case you guys want to read them. And just remember that when we talk about the submission, it's this, we're talking about the speech, the oral speech that you're giving, but like that's how you'll kind of refer to your own speech. So you just say your argument is not your argument, it's your submission. So yeah, I think that's all the slides we have today.
Thanks very much, Kelsey and team. Just one other point I would make. Obviously, when it comes to judicial intervention, the top tip is within your team, within your mooting society, is to practice making your submission and to practice asking questions, and try and ask really hard questions as well. And ask questions at different stages. Don't just ask a random question, it must be connected to the subject matter of the submission and the exact topic being considered. But make sure that you have practice in answering and being interrupted. That will make it much easier when Judge Kelsey or Judge Ananya ask you a question during your submission.
I think when you're practicing, if you take it in turns to be the judge, then you will automatically start to understand what types of questions you might be asked. One of the things I was going to ask, it hasn't been asked, but it's one of the things I get asked a lot is, could you please remind us what order the two teams will be expected to moot in?
I believe we're going with the Scottish order, which is junior appellant, junior respondent, senior appellant, senior respondent. That'll just allow us to have a bit more rebuttal. If you're not sure, there's kind of a Scottish order to mooting and an English one, and the English one does senior, junior appellant, and then senior, junior respondent. So it means that the appellants aren't really able to comment on the respondent. So we're going to go with the English, no, the Scottish order. So it'll be both juniors, 7 minutes, and then the seniors, and always it's the appellant that goes first.
Many thanks. Well, we have no questions in the Q&A. And I think that many of the questions that would have naturally been asked have already been answered. So I won't hang about too long. No questions coming up. Okay, well, Peter, would you like to wrap up for today?
Yeah, well, that was great. Fantastic session. And yeah, I answered many of these questions when I did the sessions last week, and it's great to sort of hear the team giving the same answers as well. So this is really getting into the fun stage of the mooting training, and we're really looking forward to meeting each of the teams online to do sort of one-to-one specific training on the internals problem, and we'll be sending out the problem tomorrow to all schools. You have a few days to look at it, and then we will go through it with you, each school one by one. So thanks very much from all of us back in Dundee this time. We look forward to seeing you very, very soon. So thanks from Dundee, and have a great end of the week and a great weekend.